Good afternoon, everybody. Thanks for joining us for an extra special bonus version of the 2020 OSHA webinar series. This is one of those occasions where as good a job as we do of predicting what is going to be the hottest thing in workplace safety and health law for a full year out, there was a big development, and we are excited to be able to provide some sort of instantaneous content for you about the breaking new CSB accidental release reporting rule. Like all of the other webinars in our 2020 OSHA webinar series, we are recording the program today, and within a day or two after the event, we will share with you a link to the recording of the webinar as well as a copy of the slides. And I think we already emailed out to you an advanced copy of the slides you can use for note-taking if you'd like. This is the first faceless voice you're hearing right now is Eric Conn. I'm one of the founding partners of Conn Maciel Carey, and I chair the firm's national OSHA Workplace Safety Practice Group. I have for 20 years now, and this is the 20th year, and that's crazy to hear out loud, but for 20 years I have been working with employers in all aspects of workplace safety and health law, from helping to manage inspections and investigations, to litigating enforcement actions involving OSHA, all of the state OSHA programs, the Chemical Safety Board, MSHA, and EPA, really only as it relates to the RMP program. I handle all aspects of OSHA litigation, from those citation contests through and including criminal prosecutions to appeals of citations out to the federal circuit courts. And I regularly work with employers to develop and implement safety and health programs. And I'm joined today by my two colleagues who know the most about this CSB rule of, I think, anybody in the country. Introducing Kate McMahon first. I'll tell everybody a little bit about yourself, and then Beeta, and then we'll get started.
All right, good afternoon, everyone. Good to be here today to talk to you all about the CSB's reporting rule. Just very, very briefly, I have spent my career working in the environmental and occupational safety and health field, representing employers. My specialty and focus area for the last over a decade, probably 2 decades, has been on OSHA chemical rulemakings and chemical standards that have been promulgated. In that work, I have come to know the Chemical Safety Board and the work that the board does. We developed Beeta, Eric and I, as we learned about the lawsuit that was filed against the Chemical Safety Board, forcing the board to develop this rule. We were tracking it very carefully over the last year. We saw the proposal issued in December, and we worked very quickly to gather together a number of industry clients and others who were interested in commenting on the rule. That's what we'll spend the bulk of our time today talking about, and let me just ask Beeta Lashkari to introduce herself as well.
Hi, all. My name is Beeta Lashkari. I am an associate at Conn Maciel Carey and a former attorney investigator of the CSB. I represent employers in the full range of matters regarding the OSHA Act and handle the full range of litigation related to contesting OSHA citations. I also manage inspections and investigations by OSHA, the CSB, EPA, and other federal, state, and local government agencies. It's a pleasure to be here with you today, and I'll turn it back over to Eric to go through our agenda for today's webinar.
All right, so Kate sort of clued you in on what we're going to be covering today, but before we get into the actual rule itself, that is the focus of today's presentation, we imagine a lot of people don't know a lot about the CSB, and a lot of people are Googling, what is the CSB right now? So we're going to start with a little overview of what the Chemical Safety Board is, where their authority came from, what their authority is, and then sort of that will roll into the history of this accidental release reporting rule that we'll spend most of this program talking about. And this is one of these great histories, a great Washington, D.C. bureaucracy story, that any rule, you really got to go back 30 years to begin the discussion, and that's where this one begins too, and we'll share that history hopefully more efficiently than this rulemaking. Then we'll talk about the proposed rule, what was in the proposed rule, the comments that we prepared for our coalition of interested stakeholders, the concerns that we and these employers and employer groups identified with the proposed rule, and then we'll talk about how the rule changed, and it did change a little bit. I think one of those instances where you get to celebrate that your comments made a little bit of a difference in a rule, although we don't think it went quite far enough. So we'll talk about the final rule, what we think is still wrong with the final rule, and then a potential legal challenge that we believe ought to be brought in this instance, and share with you where we think that could go. So I'm going to turn it over to Beeta, who spent a few years with the CSB, to talk about what the agency is all about and give you a little bit of an overview.
Great. Thank you, Eric. So yes, just to start, we wanted to provide some background about the CSB, what it is, how it was created, and where things stand now with the agency. There we go. All right, so the CSB, or more formally, the Chemical Safety and Hazard Investigation Board, is an independent, non-enforcement agency that conducts root cause investigations of chemical accidents at fixed industrial facilities. And you might be thinking, what does that mean? What does it mean to be independent? And while I was at the CSB, I used to get asked that all the time. What department are you under? Department of Labor, EPA? And my answer would always be the same. No, none of them. We're independent. We're not tied to any other agency. And Congress did that on purpose. Congress designed the CSB to be non-regulatory and independent of other agencies so that its investigations could focus on reviewing the effectiveness of current regulations. One thing the CSB will almost always do after their field work and when they are ready to start determining root causes of an incident is ask, are there any regulatory gaps here? How could this catastrophic incident have happened under the current regulatory scheme? Was this a situation involving a facility that just intentionally did not follow the regulations? And usually the answer to that question would be no. More often than not, it was a matter of a facility not understanding a regulation or a regulation just not being in existence. So those are the types of things the CSB will look into, and that was a large part of what I did during my time there. And Congress recognized that if the CSB was tied to OSHA or EPA, that it would be harder for the agency to look at OSHA's or EPA's standards objectively. So that is why the agency was created, to be independent. Another important characteristic about the CSB is that it is non-regulatory. The agency does not issue fines or citations, but rather makes safety recommendations to facilities, regulatory agencies, trade associations, labor groups, and others. The CSB is always looking to make the broadest safety impact that it can, so there really is no limit on who the CSB might make a recommendation to. There is no penalty for not following a recommendation, but the CSB does track its recommendations very meticulously and works very closely with recommendation recipients to achieve closure of the recommendation. There's a whole recommendations department dedicated solely to ensuring that the recommendations made are completed. Currently, the CSB has made a total of about 840 recommendations and has closed about 80% of those. So moving on to the makeup of the CSB. The CSB is composed of 5 board members who are appointed by the President and confirmed by the Senate. Board members serve fixed 5-year terms, and the board chairman serves as CEO. I'll come back to this to talk about the board's current makeup in a couple of slides, but that is generally how the CSB is governed. There are 5 board members, 5 board member seats. Not all of them have to be filled, but that's the max number of board members. What about investigators? What do they do? As you might expect, they conduct all of the fieldwork type activities that you might expect of OSHA inspectors. They gather evidence through photo documenting the site, taking samples and sending them to independent labs for analysis, reviewing pages and pages of company safety records, and so on. They also, of course, conduct witness interviews, but these tend to be very different from OSHA inspection interviews. The CSB is not asking questions to determine compliance because, remember, the agency is non-regulatory.
Rather, they'll ask broad safety-related questions that they think might be pertinent to an incident, and sometimes might even go beyond what anyone thinks could be relevant. But again, the agency is trying to determine the root cause of the incident, which really is a misnomer. There really is never just one cause, but rather a multitude of factors that contribute to an incident. So the CSB will be asking a lot of questions, and usually they try to do so in an open-ended manner. One major reason Congress decided to create CSB to be non-regulatory was to encourage open and honest dialogue during witness interviews. Congress knew that if CSB had enforcement authority, it would cause witnesses to be more nervous about speaking up. So one thing CSB investigators will always go through at the start of any interview is that it is not an enforcement agency. In addition to all the field work, CSB investigators also write the reports that are eventually put before the board for board vote and, if approved, are published. After gathering evidence, the investigators will go back to their offices in Denver or DC and start reviewing everything. Sometimes a follow-up visit might be warranted, and it's almost always the case that investigators will request additional documents. The whole process is very step-by-step and can take a very long time. Unlike OSHA, CSB is not bound by a statute of limitations, so reports can take several months or even years to be issued. Besides writing investigation reports, which might take the form of a long formal report or a shorter case study or bulletin, depending on the circumstances, CSB also investigates general chemical accidents. So, for example, after a series of combustible dust-related incidents that resulted in a significant number of fatalities, the CSB put out a combustible dust study, which sort of synthesizes the key findings from the individual incidents and determines the commonalities among them. In this study, the CSB also recommended that OSHA develop the combustible dust standard, which, of course, is still an open recommendation. But this is just another thing that the CSB might do, is issue a hazard investigation with broader studies of significant chemical hazards. Okay, getting into the current state of affairs. Historically, the agency has always been a very low budget agency of around $11 million per fiscal year. That has not changed. But what has changed since the beginning of the Trump administration is that the president has proposed a budget to completely defund and eliminate the CSB. You'll see even on the slide, even in the most recent budget, the CSB is again up for elimination. But thankfully, at least for the agency, Congress has continued funding support for the agency, so it continues to operate. So nonetheless, even though it continues to operate, it is in a much less healthy state than, say, 4 or 5 years ago. Since the start of the Trump administration, CSB's governing body and investigative staff has declined dramatically. Currently, the CSB has only one board member, who is interim executive authority, Kristen Kolonowski. And she took that position after former chairperson Vanessa Sutherland cut her term short and stepped down last summer. That left a 3-person board with board member Kolonowski filling in for Chair Sutherland. And the remaining 2 board members' terms have just recently expired. And just FYI, the board member Kolonowski's term expires in August of this year. So what does this all mean for the agency? Well, right now, the governing body does not have a quorum to maintain full functionality. So the CSB is drafting a contingency plan to account for this. And if no new board members are nominated or confirmed soon, the CSB may not have a governing body at all. I've got more on this on the next slide, but first let's talk about the number of investigators. While I was at CSB in 2015, for example, there were about 20 investigators, and they were located in both Denver and DC offices. That also helped with deployment situations, since geographically there is more coverage. Today, though, there are only about 6 investigators total, all of whom are in Denver, or maybe 1 or 2 in remote locations. That is really significant because the investigators are the ones who, again, not only do all the field work, but also go back to the office, determine the root causes of the incident, write up the reports, develop the recommendations, and of course, the topic of today, screen incidents for deployment consideration. So without a sufficient number of investigators, really the bulk and primary purpose of the agency's work cannot get done. Okay, so going back to the board members really quickly, there is this threat of no governing board looming out there if no one is confirmed by August 2020 when board member Kolonowski's term expires. But there is some hope. On June 13th of last year, the president did nominate Catherine Lemos from Northrop Grumman to become CSB's chair. And in September, the Senate Committee on Environment and Public Works held a confirmation hearing and approved her for consideration by the full Senate. So the only step left is for her to be confirmed by the Senate, and then the CSB will have at least one board member and chair instead of being left empty without a governing body. And as to the last point, like I mentioned, CSB investigators do the bulk of the agency's work. So now that there are only about 6 total investigators, it's hard to see how they can manage the CSB's current caseload, let alone the one that's about to hit them under the new reporting rule, given the flood of reports that are expected to come in. Okay, with that, I'll pass it over to Eric to get into the reporting rule and to start off with the history of the reporting rule.
Thanks very much. It's a helpful reminder about what the CSB is all about, and now let's talk about this rulemaking. And like I said, this story begins 30 years ago, back in 1990, when the CSB was born on paper. And the CSB's enabling statute, the Clean Air Act the Clean Air Act Amendments of 1990, created the agency and required in the statute for the CSB to establish reporting regulations so that there was a duty for employers to report to CSB the events that would be the subject of CSB investigations. For almost a decade, the agency existed only on paper, so I won't fault the CSB much for not making progress on its rule in that first decade where the agency was not even funded yet. In 1998, the CSB was funded and became operational. They began to, build up a staff, put together memos of understanding, and start to develop their field strategy, although I don't think they actually responded to the first incident until around 2000, but I can check that. In June 2009, so almost another decade passed before the CSB did really take official action, public action on this rule, and that was publishing an advanced notice of proposed rulemaking for release reporting. And if you look back at that, and we did as we were preparing comments for this rule, there wasn't, proposed language for a rule like you see in a notice of proposed rulemaking, but there were some ideas for how this rule would operate or how this rule might operate if it was promulgated. And it looked like, a pretty innocuous rule. And so dating back to 2009, we all thought, well, if they ever get around to finalizing this rule, it probably won't be so onerous, it won't be so burdensome, and it won't sweep in that many incidents, and may, in fact, not require any proactive action by employers, but instead that if you are contacted by CSB, then share certain kinds of information. So we all looked at this and said, that's not bad. That, as far as reporting rules go, this is one we can probably live with. But that advance notice of proposed rulemaking stagnated. It never turned into an NPRM, and there was no real further public action after that. So in 2017, the end of 2017, some activist groups, environmentalists, some government officials banded together and filed a lawsuit against the CSB in federal court seeking to mandate that the CSB move forward with this rule that its enabling statute required them to promulgate, 27 years earlier, 29 years earlier. At that point, the CSB actually defended the suit pretty vigorously, saying, we don't need this rule, we're doing fine without this rule, you know, give us lots of time if you're going to order it, and shared all sorts of information in its defense against that suit that, you know, really was fairly remarkable in contrast to the rule that they ultimately proposed, and we made use of that in our comments about the rule as well. But eventually, in February 2019, a D.C. District Court, you know, judge said, well, listen, you know, just notwithstanding all that you're saying, it all sounds great, probably don't really need this rule, but the statute says thou shalt establish this reporting rule, and so you've got to do what the statute says. Unless or until Congress changes what the statute says, you must do this. And since it's been almost 30 years now, we are going to give you 12 months and 12 months only to finalize a rule, a reporting rule. And so, of course, the CSB does exactly what I used to do with my homework back in high school and waited till the very last minute and issued a notice of proposed rulemaking, February to December, 10 months later, with only 2 months left in their deadline to get a final rule, to get a rule finalized and published in the Federal Register. They issue their notice of proposed rulemaking. We'll get into the detail about that, but we and many others in industry were surprised, blindsided by the nature of the rule. It was much more burdensome, much more onerous rule than what had been projected in the advance notice of proposed rulemaking, and then when you watch the CSB defend really the lack of need for the rule at all, we were very, very surprised to see what this rule looked like when it was proposed in December. They gave the bare minimum of days for industry stakeholders or any interested stakeholders to comment, refused. I'm not sure if there were multiple, but there was at least one request for an extension of time that I submitted, and encouraged the CSB to go back to the court or even to go to Congress to get more time or to eliminate the call for this rule at all. They declined the extension of time, and so comments were submitted, and less than a month later, CSB issued its final rule, which is an extraordinarily short period of time to think that the agency gave real consideration to the comments that were submitted. So let's talk about what that proposed rule actually looked like. It essentially required owners and operators of stationary sources, which is basically anybody who is not out on a railroad track or out on a DOT-covered roadway, public road, a stationary source, owners and operators of those stationary sources, to report to the CSB within 4 hours details about any accidental release that results in a serious injury, substantial property damage, or a fatality. And the details about the rule that were the most troublesome to employers were how the agency defined, well, I mean, really it's all of that. It's this 4-hour time window, which is shorter than reporting even a fatality to OSHA, and let alone some of the other types of incidents, a property damage incident to be reported within 4 hours, a very tight window, usually when there's a lot else going on at your facility, like an emergency response, like dealing with other reporting requirements, and like evaluating the impact of an incident that has just occurred at your facility. So a very short time period, very, very broad definitions of serious injury and substantial property damage. I think we've got a slide in here with the details about this, but in short, serious injury was defined as essentially any injury or illness diagnosed by a doctor or licensed healthcare professional. Any diagnosis. And so this goes even beyond OSHA's recording requirements. I'm not even talking about when you have to pick up the phone and call OSHA. I'm talking about when you have to make those little notes on your OSHA 300 log about an injury that results in a day away from work, or a job transfer, or something, or medical treatment beyond first aid. This rule goes beyond even those three requirements. Even if you don't miss a day of work, you don't have to have a restricted job duty for even 1 day, and you don't even get medical treatment beyond first aid. You don't even have to get treatment by first aid to be covered by this rule. If a healthcare professional says, here is an official diagnosis for what happened to you, and it could be, inflammation in your throat or your lungs from breathing something in. But there's nothing, we're not going to treat it with anything. That would be a serious injury reportable to the CSB if it relates to an accidental release of a chemical. Substantial property damage, CSB defined in this rule as a $1 million threshold, but it includes outside property damage and it includes loss of use of equipment. And I talked to a lot of employers about this rule when it was in that proposal stage, and I said, about how long would you have to have a unit down at your petroleum refinery before you achieved $1 million in loss of use damage? And the answers ranged anywhere from about 30 minutes to certainly less than 1 day. And so you can see if you count loss of use, let alone impact outside the fence line, which is very, very difficult to calculate, certainly very difficult to calculate in 4 hours. This is a much broader impact than I think a lot of folks expected. There is a quasi-exception to the reporting requirement, and that is if you have already reported to the National Response Center, to NRC, then you sort of don't have to report to the CSB. But the reality is, even if you have, in the proposed rule, reported to the NRC, you still have to, in the proposed rule, immediately contact the CSB and share with the CSB the NRC ID number associated with the report that you've just made to the NRC. So while it is technically you're not required to give all of the details you're otherwise required to give, you're still required to pick up the phone or submit the form to the CSB to notify them that you've already reported it to the NRC. So it's not really much of an exemption. Here is the content of the report that is supposed to be made to the CSB if you meet one of those threshold reporting triggers. The name and contact info for the site, the person making the report, location, facility identifier, about what time the incident occurred, a brief description about the release, and then talking about the consequences here. Did it trigger a report because it was, did it result in death, serious injury, or property damage? Was there a fire or explosion associated with it as well? To the extent you can, identify the materials involved in the release. That's part of the initial reporting requirement. And then there's a few of these instances where it says in the proposed rule, and Kate can talk about this in some detail about the final rule, is if known. So there's at least a little qualifier in there that we get it. It's only been 4 hours, according to the proposed rule. If known, share the amount of the release, the volume, the number of serious injuries and fatalities occurred. If known, share information about weather evacuation orders, the scope, the scale, the radius of the evacuation zone, and so forth, and an estimated property damage within your stationary source or outside the realm of your stationary source. So that was the content of the report required. The last thing that we talk about here about the proposed rule is that despite, as Beeta described the CSB as a non-enforcement agency, no ability to issue citations and penalties and fines, with this rule, there is stated in the rule that the CSB, if it identifies or believes that violations have occurred, either no report was made at all, the report was wrong, it left out information, or it reported wrong information, the CSB will refer that, or has the authority to refer that to the EPA administrator for enforcement by the EPA of this violation, which could include administrative penalties, and this is under the Clean Air Act, the Clean Air Act amendments. So presumably the penalty authority looks like EPA's penalty authority for other Clean Air Act violations. And I believe last time I checked, that was roughly $100,000 per day for violations of this. This is something we've got to explore in more detail, but assuming that it is the same penalty authority under the Clean Air Act, it's no joke. And, this is a reporting rule, but if EPA gets involved and they start to apply these per day penalties, this could be a very significant enforcement action. And there is also, if this is being enforced under the Clean Air Act, potential criminal effects of that as well. So this is a, thought to be no big deal, fairly innocuous reporting rule. If you look back at the advance notice of proposed rulemaking for this independent agency that doesn't have enforcement authority, it's turned into a very burdensome, onerous rule with potentially very significant enforcement ramifications as well. And the other ramification for this that I think is important and significant is that there's all this new data and all this new information that we are going to be sharing with the CSB about what could be extremely minor incidents, but reported to the CSB nonetheless. That information is all publicly available. Right now, what the CSB is saying is that we are not going to sort of immediately publish the information on our website or otherwise, but it is certainly FOIAble, and we will share it without putting up any fight under one of the FOIA exemptions. And so if you think about when you see the media coverage about an incident, and I watch this and it sort of, annoys me a little bit when I see it happen, that the media will say, this company has been inspected by OSHA 15 times in the last 25 years, or this company has been cited 5 times with 5 serious violations from OSHA in the last 10 years. Now, anybody that knows anything about OSHA knows that 75% of the time that OSHA knocks on the door, they issue citations, and 85% of those citations are at least serious or worse. But the media reports this like, my God, this is a terrible actor that's had all these inspections, that has all these serious enforcement actions. Well, here's another data point that the media is going to grab hold of and say, this company that's just had a release or just had an explosion or a fire or some kind of incident has reported a dozen other serious incidents to the CSB in the last 5 years or 10 years or whatever. So this is another public data point that will be taken out of context, misunderstood, or maybe even understood correctly, but purposely distorted to embarrass employers after incidents. So the fewer incidents that need to be reported to the CSB, the better, and that is why we saw this proposed rule and we pulled together a group of interested employers and trade associations to try to fix that, what we saw as a overbroad rule. And Kate's going to talk about the concerns that we identified in the rule, the comments we submitted, and what impact that has already had on the rule and where we think we should go next.
Thanks, Eric and Beeta. All right. Well, we're going to spend the remainder of our time talking, as Eric just said, about the concerns that we identified with this rule, and not only those concerns, but suggested mechanisms that could address the concerns that we identified. And as we talk through this, we will share with you, importantly, how the rule has changed from the proposed rule that Eric just outlined to the final rule, and about some additional changes that we think are necessary. All right, well, this slide here sort of summarizes the major issues that we identified with the proposed rule, and then we've got slides for sort of each one of these. So let me just sort of tick these off, and then we'll get into a little more detail about each of them. The first major problem with this rule, and this, to me, this is an extremely fundamental issue with the proposed rule and even the final rule as it exists today. It is unnecessary. The problem, in a nutshell, is that this requirement was established in 1990. The rule was developed in 2019/2020. The world changed in that period of time, and we'll talk a little bit in a few minutes about how it changed and how those changes rendered this rule no longer necessary. Second, procedural concerns, and this too is very serious. The procedural concerns that we have, as Eric and Beeta mentioned, were that, the CSB, for reasons that obviously we've only got limited window and insight into what was happening internally, but there were various publications that were made during the litigation brought in 2017. And from that litigation and those public-facing documents, we were able to get some insight into the CSB's own view as to whether the rule was necessary. It looked to us as if the CSB thought, as I just explained, and we'll talk about it in a little bit, the rule no longer is necessary. Well, that may be why they may, drag their feet, might be a little unfair to describe the CSB's actions, but regardless of the motivation, the proposed rule did not come out until December, as Eric mentioned. Industry had to scramble to review it, understand its implications, and develop comments. And even though, as much as we scrambled, the CSB had even less time to thoughtfully consider those comments. So I'll talk a minute about, some suggestions we have as to how the CSB ought to respond to the actual comments in the rulemaking. Third issue, the Clean Air Act amendments of 1990 include statutory language that indicates that if you have filed an NSRC report, you have, in fact, satisfied the reporting requirement. I'll talk about why we think that means that if you file an NRC report, you should be exempt from this rulemaking entirely. As Eric already pointed out, the definitions of serious and substantial property damage were extremely broad and unworkable. The 4-hour notice period was far too short in our view. The focus in those first immediate hours after an incident of any proportion at all ought to be on first response. Employee and neighboring, people's protection and safety. Reporting to regulatory regulators is important, but it is not critical in terms of, it should not be done in lieu of making sure that your people are safe and protected. Number 6, the concerns that Eric referenced, the agency resources. I'm going to talk more about that in just a minute. Data security, protecting the information that has been provided to the regulator, and this enforcement issue that Eric mentioned a minute ago. Finally, just sort of a catch-all, there are a lot of reporting obligations that companies have to comply with very shortly after an incident, and they're sort of a web of these requirements. They're all different, and this just sort of adds on to another layer of different regulatory obligations that employers and owners-operators that have an accidental release have to keep track of. All right. I don't want us to harp too much on this, but I also want to make sure everyone understands that this concern that we have identified is not some, anti-regulatory, business-friendly concern. Sure, we want to make sure our companies have enough time to report. We want to make sure the reporting serves a good purpose. But as much as we're concerned about protecting employers and owners-operators, we also believe that this rule, if promulgated as finalized, is going to really bog down the CSB. The CSB has a critical mission. That mission is to investigate and develop safety recommendations associated with major catastrophic releases, right? If this rule goes into effect, as it looks like it's going to under the final rule, to broaden the net, to collect as much data as we think, even with the changes that have been made in the final rule, we think that this rule is going to completely bog down the agency and prevent it from achieving its mission, which is to develop safety recommendations associated with really major catastrophic incidents. The CSB currently receives NRC reports. Every NRC report that is made is promptly provided. We think that happens within 24 hours of the NRC receiving the report, is promptly provided to CSB. All right, so CSB has every single report that is made under CERCLA 304 or 307 to NRC. Number 2, media reports. And here's the difference between 1990, when Congress mandated that this rule be created, and today. a little thing called the World Wide Web was created. In 1991, I believe, there was a computer programmer named, little-known name, everyone thinks Al Gore created the Internet, but actually Tim Berners-Lee created the Internet. Actually, he actually expanded the Internet. It had been in use in limited capacity by governments, and particularly in the Defense Department in the United States. But there was, after 1991, an explosion of the use of the World Wide Web and the Internet. Right now, CSB, of course, has access to every single story that is loaded up onto the Internet. And the Internet captures essentially everything from the major explosions that tragically occur in the United States to the little fires in some, backwoods corner of the middle of the country where, a local reporter writes about a fire at the local bakery, and that gets picked up by UP and API, and that is on the Internet literally within minutes. All of that information is accessible and is currently being screened by the CSB. To add to that, the exponential increase of reports pursuant to this rule will really bog down the agency. And ironically, none of these reports, in our view, none of the reports that come in through this rule that aren't also identified under the current sources will be investigated. Look at the data that we've got on the bottom of this slide. From 2009 to 2019, 10-year period, the CSB learned of approximately 2,000 incidents, accidental releases. They screened those incidents, and they actually deployed to only 50, the 50 most catastrophic or important for the CSB to achieve its mission. The CSB, as Beeta reported earlier to you, now, unlike during that time frame where there were somewhere 20 and above staff people doing this work, now has 6 people. There is no way any of the data that comes in through this report that they don't already have from either NRC or the media is going to be investigated by the CSB. So what this will do is it will take all the precious resources that the agency currently has that could be used on investigations and report development and move those to the screening of this broad net of data that will be developed through the rule. Okay, procedural concerns. We're lawyers, right? So this counts. This is important. Under the Administrative Procedure Act, there are requirements. They are fundamental to ensuring good rulemaking. In our view, I think it is a really close call as to whether the fundamental obligations of the APA notice and comment requirements were met by CSB. They promulgated the rule, as Eric said, on December 13th. They gave the public 1 month to comment. And even though this rule, you could say in some ways, as Eric sort of joked in the beginning, sort of started in 2009 with the advance notice of proposed rulemaking, there was nothing in that advance notice of proposed rulemaking that would have been foreshadowed or telegraphed to industry or environmental groups what this scope of this rule would be like. And in fact, the comments and the public-facing documents that were filed in the litigation would suggest that the CSB did not think that a rule of broad scope would be necessary. So it really did take industry, and it took everyone by surprise, I think. And we had 30 days to comment, no extension granted. So I don't think that meets the spirit or possibly even the letter of the notice and comment rulemaking requirements. However, frankly, even more concerning than that is the amount of time the CSB gave itself to actually finalize the rule. We know, I've spent, 20 years working with the agencies in the context of chemical rulemakings. I know what happens behind the scenes. I know how important it is for agency personnel and subject matter experts to sit and meet and talk about the impact of a particular comment. I know that the APA requires agencies to address significant comments. Here, although we did have some, a couple of key significant moves, revisions that the agency made, I'm pretty convinced that the agency did not give itself enough time, as required under the APA, to give thoughtful consideration to the comments that were submitted in that 30-day comment period. So the public had insufficient opportunity to comment, and CSB had insufficient time to give meaningful consideration to those comments. That's a violation of the APA and a reason that this rule ought to be sent back to the agency if litigated for further consideration. All right, now let's get into some additional meat on why we're concerned about our concerns. And all these points, by the way, we made in the comment that was submitted on behalf of this industry coalition, and I'll talk in just a little bit about, the changes that were made and what remains to be done from our perspective. Okay, I referenced a little while ago the statutory language of the Clean Air Act amendments. Here we quote in our first bullet on this slide, reporting releases to the NRC, to the National Response Center, in lieu of the board directly, shall satisfy such regulations. That's pretty clear, pretty straightforward language, especially for statutory language. It seems to me that what that means is reporting releases to the NRC in lieu of the board directly shall satisfy such regulations, right? I mean, what it means is if you submit a report to the NRC pursuant, by the way, to sections 304 and 307, I think the Superfund, so the CERCLA, you have satisfied your obligation under this requirement. Yet, the way the rule was proposed and finalized, even if you do that, you still have to make a report to the CSB. Now, the report does not have to be the full, report and including all the information that you would have to make if you didn't report to the NRC. But, I know this may sound picayune, but here's the deal. This is in the immediate aftermath of in some cases, catastrophic event at your facility. There may be fatalities, there may be fires, there may be terrible accidents, you may not be able to account for people. Even though they've lightened up the amount of time you've got to kind of match it up to OSHA's requirement for 8 hours for fatality and hospitalizations, that's still very early in the process after an accident. And, I know how employers work in terms of reporting obligations. I know that, to be careful and cautious about making sure you don't violate the law. The legal departments often get involved, the EHS people are involved, different people than the plant manager are involved because the plant manager and the local folks are busy with first response. So it kind of gets in this web of corporate protocol. And if someone has, I guarantee you, if someone has made a report to the NRC, there are going to be many employers and owner-operators who fall under this rule who will think they have satisfied their obligation and who will not think, oh, we've got to call up the CSB and tell them we just did this. That's going to fall through the cracks in this immediate aftermath, and that's a violation of the law. And as Eric and Beeta mentioned, that means an employer is subject to, an owner-operator is subject to an enforcement action under the Clean Air Act. I don't think that's necessary, and I don't think the statutory language would allow that sort of a requirement to be built into this reporting requirement. All right, that's that. Next item, serious injury. Eric has already described to you that in the proposal, the CSB broadened so broad that the trigger for reporting in the context of a serious injury. They did fix that. I frankly believe it was probably an error on their part. I think it was inadvertent, but we commented, as did a number of other entities that commented on this proposal, that the definition was way too broad. And CSB did make a significant change here, and one that was welcomed by the owner-operator community, and that is they matched up the serious injury definition to meet the OSHA reportable injury definition of a fatality or an inpatient hospitalization for treatment beyond diagnostics, an amputation or loss of an eye. Now, the good news about this change is twofold. One, it does narrow and make what is reported to CSB at least closer to identifying, incidents that ought to be screened by CSB. I don't know that it gets there when we know that there are 6 staffers and, they investigated 50 incidents in a 10-year period, but it at least gets closer. Also, importantly, it matches up the regulatory obligations. So it lessens the sort of thorny spider web of, different timeframes and different triggers for reporting. So at least we now know if you have an OSHA reportable and it is caused by an accidental release of a stationary source, that same reporting obligation applies to CSB reporting. So that was a good thing. Substantial property damage. Even though we submitted comments on this, this did not change in the final rule. And so to get a little more detailed beyond Eric's initial comments on the substantial property damage definition, as we mentioned, the CSB's proposed definition said substantial property damage means you have a threshold of $1 million. And also, as Eric mentioned, that includes loss of use of equipment, that is downtime, and it includes property damage beyond the fence line. A major concern that owners, operators have with this definition of property damage is that it really does take, way more than 8 hours to properly assess whether you've got significant property damage outside the fence line, or whether the fees are running on the calculation of loss of use. It's not something employers immediately start thinking about, contrary to maybe popular opinion. The focus is not on, how much money are we losing? The focus is on safety of their employees, ensuring first response is done properly, getting the equipment down, and then, of course, later, the financial people come in and sort of figure out, okay, what was the cost of this accident that happened. Now, obviously, where there are major catastrophic incidents, you may know immediately that this is going to meet the $1,000 threshold. But because the scope of the rule is still so broad, there are going to be a huge number of potentially reportable incidents. And companies are going to be put in this uncomfortable position again of making that difficult call, and when you've got in-house lawyers making, prudent judgments about whether to make a call or not, do you report on the air, do you err on the side of caution and report even though you don't know that you've triggered that this is a reportable incident, and you're not going to know for probably weeks, at least days, maybe even longer, maybe months, if it's right on the cusp. And there are going to be a lot of those. I think based on the way this rule is written, this isn't just sort of a one-off type thing. There's going to be a fair number of these that are sort of the borderline ones based on the property damage trigger. And so you're not going to know. So, do we advise, okay, or in-house counsel says we better report because it might be and we don't want to violate the law, or you know what, I don't want to trigger some potential investigation or broadcast this, have me being one of these reportable industries to CSB, which connotes you're like had a really terrible accident if you don't have to. So it's going to cause perhaps erring not on the side of caution, and you don't report, and then 3 weeks later you get, reports from neighbors, or you get your calculation from your accountants that the lost use time was over $1 million, and you just erred. You didn't report when you should have. You missed your deadline. So that's a problem, although there is some way to fix that under the regulation. I'll talk about that. The other thing to point out is the last bullet here. Virtually all CSB investigations have involved a fatality or serious injury. I mean, look at the data that we've got in this chart here. Of the 1923 incidents that we talked about earlier that were screened between 2009 and 2019, not many of those at all had just a property damage component without having either an injury or a fatality. I think if we're reading this chart right, and I'm going to look at Beeta and make sure I'm right about this, I think there might have been only 23 out of those that had only property damage. I think that's right. But anyway, bottom line is it was a very small number. So, I mean, you could argue that you'll pull in all the accidental releases that need to be reported if you just focus on fatalities and serious injuries as redefined in this final rule. All right, and then I think this might be the final, oh yeah, a couple more points. You know, I think I've made this. There are duplicative reporting requirements. No one's asking for, you know, a weeping party for all the obligations that companies have to meet, but there are a number of them. And 99.9% of the companies that we represent, all of the 100% of the companies that we represent want to do the right thing, and that is report in a timely fashion. But they have this web of requirements, and this just kind of adds to the burden of making sure you do right by all the different regulatory agencies. The short reporting window, Eric mentioned the proposal required reporting within 4 hours. That was less than even the OSHA fatality reporting requirements. That was another change, a big and important one that CSB made in the final rule. And we did have some data that we submitted in the comments about a report from the Society of Safety Professionals in the 2009 Advanced Notice of Proposed Rulemaking, indicating that for, you know, sort of the average accidental release, at least the first 3 hours, at minimum the first 3 hours, are necessary for post-incident emergency response, and that really should be the focus in those hours. That sure didn't leave a lot of time to report under the proposed rule. So CSB revised the final rule to give us 8 hours instead of 4. Very good change. Okay. Oh, just one other point, and this was not fixed in the final rule or addressed in the final rule, but the current final rule, although it gives 8 hours now, not 4, does not include a knowledge trigger. So unlike the OSHA fatality and hospitalization reporting rule, where the clock begins when you as an employer know about this incident, here there's no knowledge report built in. And, you know, we'll have to wait and see how this thing actually is enforced and rolled out. But right now, as the language of the rule is written, there is no knowledge trigger. And I know that may sound silly, and it is silly in the context of some catastrophic incident, but it isn't silly in the context of a minor incident that might be a relatively minor incident, having no fatalities, no serious injuries, but having property damage, where there's downtime of, you know, a boiler room and all the equipment in the boiler room or near the boiler room. So that's, we believe, still a problem that ought to be addressed. All right, a few other concerns, and let me move on to the final rule. We're, I think, staying pretty on track here in terms of timing. Okay, lack of agency resources. I know I'm harping on this. I started out there, and I want to kind of end this discussion here. There is no way this agency, in my view, is going to be able to review and screen all of the new data that comes in under this rule, even though it has been narrowed. What that means to me is that the precious resources available to the agency, the money and the people, the staff people, who are doing the job of screening and deploying to incidents and investigating those incidents and developing safety recommendations and tracking to make sure those safety recommendations are actually implemented. More of those resources, to my mind, too large a percentage of those, to our mind, too large a percentage of those resources are going to be devoted to reviewing the film and then cutting it out and leaving it on, you know, the proverbial floor of the editing room, the stuff that they just pulled in by the new rule. So it's going to really just waste precious agency resources. Data security. There was some concern mentioned to us by a number of owners and operators who might be in a situation someday to have to report that this information that's being reported is going to include some data that is going to pose a problem if it is publicized. Now, right now, the CSB does not plan to release, at least according to the rule, the CSB does not plan to release the data that it gathers pursuant to this rule. But two things. One, that's the current, board or leadership at CSB. We don't know what a future board might look like, and we don't know what a future board will decide. At OSHA, for instance, under the electronic reporting rule, we had the previous administration under Dr. David Michaels, who did believe that it was a good idea to upload onto the OSHA website, the public-facing website, all of the electronic reporting rule data that it gathered pursuant to its 2016 rule. The current Trump administration has decided to not upload that data. So, depending on the politics of the board, there may or may not be an uploading and publicly sharing of this data that is gathered. One thing that I can tell you right now, if you're an entity that had a CSB release, right now, that's a bad thing. And it connotes like, oh, this was a really terrible thing. And those are connotations and views that companies would prefer not to be associated with. Certainly if they have a catastrophic release and the CSB legitimately comes and investigates, well, the chips fall where they may. But when you have one of these sort of relatively minor releases that certainly wouldn't be investigated, but you're still up on some CSB data, incident report, that connotation may still be there. That's a real problem. Also, the report all these reports that are submitted to CSB may be FOIA-able. That is, if someone, anyone, a public citizen group, another competitor submits a FOIA request, that will be potentially available to whoever gains access to that data, and that entity can then publish it. So there is a data security issue and an optics issue that is a concern for owners operators that are potentially pulled into this rule. Finally, as Eric mentioned, and as Beeta described, I think eloquently in the description of the CSB at the outset of this webinar, there is something, I guess I'd say, special about the CSB, this sort of unique non-enforcement role that it plays. And it is designed, as Beeta said, in order to ensure frank, open, honest discussions with CSB after an accidental release. I, know how this works. We know how this works. If these reports are going to be, or a purported violation of the reporting rule are going to be forwarded to EPA for enforcement under the Clean Air Act with the stiff penalties of the Clean Air Act, which are, way exponentially beyond those of the OSHA Act, by the way, ironically enough. That is, it changes, potentially it changes dramatically the nature of the CSB, and that could have a spillover to CSB investigations, where the whole point of Congress giving it no enforcement teeth was to encourage open, honest dialogue in the context of those CSB investigations. So changing the enforcement mechanisms here may be something that would keep and retain that unique relationship CSB has with entities that have accidental releases. Okay, our next slides are about the proposed versus final rule. I think what I'm going to talk about just very briefly, I think I've already mentioned, so I'll just fly through this. What changed? There are two major changes to the final rule. Both of them, I think, welcome to the regulated community. And I don't know, but I suspect that the unions who commented on the proposal, and also the public citizen group would not have a gripe with these changes. They are, just to remind you, one, the definition of serious injury was dramatically narrowed, I'd like to say, based on the good comments that we submitted. And these were not, to my mind, these were not like slash regulation. These were protect the mission of the agency comments. And so now at least we have an alignment between the serious injury trigger of the CSB reporting rule and the OSHA fatality hospitalization reporting rule. Second, the 4 to 8 hour time period that is allowed under the rule to submit a report. As I mentioned, not only is it a little more time to get your act together and get your report, your regulatory obligations met, but also it aligns with another reporting rule, a major one, OSHA's, which is a really serious one and has to be met. And so it, it sort of makes it easier to keep track of all these various different obligations. Also, I want to mention here that it is important to note that the rule does allow owners and operators to submit revised or updated reports within a 90-day period. That's greater than the 30-day period that was allowed under the proposed rule, by the way. Within a 90-day period, if they can explain why the update couldn't be made within 30 days. Now, that extra sort of explain why stuff, I don't know. To my mind, I think it's a good thing that owner-operators have an additional 90 days, and this, I think, applies most likely in the situation, almost all, I think, will apply in a situation with the property damage $1 million trigger, and you just don't know. And let's say you decide you're not going to report because you just don't think you're going to hit the $1 million, and then you do because you get, reports from, you decide that, I need to go offer to do car washes to my neighborhood because there was some stuff that was spewed out on cars, outside in the parking lot and in nearby parking lots or something. And it's, I've dealt with a situation. It was innocuous, but it, it left like a film on the cars. And so, there was money spent cleaning up the neighborhood. That's a sort of a black and white example, but that's one where you might spend enough that you put yourself over the $1 million. You have 90 days to figure that out and to revise your report. That's a good thing. And then also a new thing that was included in the final rule was a interactive PDF form that is available on CSB's website, so you can, fill in the form. I probably have to print it out and write it in and fax it in because I don't know how to fill out interactive forms, but most of you probably do. So, so that's a tool that's available to you that might make it, a bit easier. Okay. Beeta's going to talk for just a minute about what stayed the same in the rule, and then we're going to close talking about a possible litigation challenging the rule and why we would suggest doing that and what the goal would be. And it's maybe different than you think, so don't hang up yet. Give us another 10 minutes here.
Great. Thanks so much, Kate. So again, I'll just sort of fly through this, but just want to touch on some of the differences between the proposed rule and final rule, but talking about what stayed the same. So first, the agency did not decide to change the NRCID requirement, as Kate mentioned. It explained that, right now CSB receives NRC reports of incidents that are within CSB's jurisdiction, but CSB explained that that wouldn't cover all of the of the incidents within their jurisdiction. Along the same lines, CSB rejected suggestions to avoid duplication of other existing reporting requirements, again saying that those sources do not capture all of the incidents within their jurisdiction. Okay, going on to definition of ambient air, CSB decided to keep its definition, further explaining its rationale for including air inside of buildings despite EPA's definition of ambient air in its NAICS standard and in associated case law to air external of buildings only. The CSB made clear that the purpose of CSB's CSB is to serve the safety interests of members of the general public and workers. So air inside of buildings must be covered for worker protection. Next, the CSB retained its definition of extremely hazardous substances, explaining that a key function of the CSB is to make recommendations to the EPA about improving the rules designed to prevent chemical accidents, which includes recommendations to the EPA administrator about the listing of new substances. Going back to how Congress developed the CSB, part of that was that it was established specifically to look past established statutory criteria and already understood hazards. In the final rule, CSB said the hazard investigation function of the CSB includes identifying new, previously unknown hazards, even those caused by substances not yet discovered or in widespread use. So a narrow definition of extremely hazardous substance based on previously established lists would frustrate a key objective of the statute. Next, as Kate mentioned, CSB kept its definition of property damage, including its application to loss of use of equipment, explaining that if property sustains enough damage that it cannot be used properly, that clearly amounts to damage, just as the complete destruction amounts to damage. And CSB also retained the $1 million threshold for substantial property damage. And that is probably because it received comments, the CSB received comments in sort of all direction about this $1 million threshold. One, in support of the threshold, two, against the threshold for being too high, and third, against the threshold for being too low. And going through these quickly, CSB also did not change its definition of stationary source, despite there being a comment suggesting that it be limited to stationary sources that are regularly staffed. CSB said that the increase in the reporting time from 4 hours to 8 hours should give owners and operators ample time to learn about releases, even in more remote parts of a source. Also, the final rule did not change any part of the required content of the report. So the content, saying that, the content requirements are minimal and much of the information need not be reported if unknown. So all those qualifiers about if unknown, do not need to be filled out if still unknown within 8 hours after the release. The CSB kept its enforcement provision as proposed, saying that it will retain discretion to refer violations and rejecting any notion of a threat to the unique role the CSB has historically held with industry and other stakeholders. And lastly, the CSB did not make any changes to the public availability of records provision, which allows the reports to be made available through FOIA. Despite one commenter who suggested that the reports be made public automatically, the CSB responded to that comment by saying the rule is a reporting rule, not a disclosure rule. So that's sort of a summary of what stayed the same, and I'll now pass it back to Kate to wrap up the final rule and talk about those legal challenges.
All right. So where do we go from here? As you know now, the final rule was promulgated, was issued pre-publication on February 5th, and it was just in the Federal Register on February 21st, this past Friday. It's really important to know, if you think you will be unfortunate enough to have to ever deal with this or have to deal with this in the next short little time. One, the rule becomes effective 30 days from Friday, so March 23rd, I believe, the rule becomes effective. It's not even though it's been published, it's not in effect until then. So nothing gets reported in this. Nothing gets reported pursuant to the regulation in this next 30 days. At that point, the CSB is providing a year to entities that may have to report to sort of, come up to speed. They're going to do education on it. You're required to report for sure if you have an incident that is triggered, that meets the triggers here. But CSB has indicated in the final rule that they are not going to pass on for enforcement purposes to EPA a failure to issue a report in that first year, unless, it's a knowing failure. If there's an intentionality about it, if you know you should report and you don't, then you're certainly subject to enforcement action. But if it's an inadvertent error, you don't know you meet the trigger, you don't know about the rule, although if you're on this webinar, you probably will know about the rule. So, then there won't be an enforcement. But then after a year, this rule is going to be rolled out from an enforcement perspective. So what do we do? Under the Clean Air Act, I think I'm supposed to be moving the slide along here. Yeah, sorry. That slide tells you what I just told you. Under the rule, one thing to note, CSB has indicated that it's going to issue some guidance. I'm guessing in the next year or so, they're going to roll out some guidance. Interestingly, the agency is going to provide additional information and guidance on whether an explosion is a per se accidental release. It meets the standard, it's a qualifying event, and you have to report. Also, interestingly, the CSB is going to issue information about whether serious injuries that result from an intentional release, that, like a controlled discharge, fit within the definition of a reportable event. And finally, there are a lot of commenters comment on this issue of extremely hazardous substances and narrowing the rule to cover only those things that meet that definition. That was not an issue that we raised a comment for reasons that we won't go into here, but relating to this original mission and scope of the CSB. We're going to get some guidance issued by the CSB on the definition of extremely hazardous substances. So all of that will be very interesting to see. But why are we suggesting a legal challenge? It is not so that, industry and CSB can be embroiled for years on end in a litigation matter. That's not what the objective would be. The objective would be to file a petition for review under the Clean Air Act in order to sit with the CSB to negotiate further to tailor this rule to be the kind of rule, if you're going to have a rule, okay? Now, I believe that the changes in the world between 1990, when Congress legitimately included in the Clean Air Act this requirement for a rulemaking on a reporting rule by CSB and created the CSB, I believe that those changes really negate the need for this rule. I honestly do believe that. I think the CSB is doing just fine right now. I mean, with the limited resources, as Beeta mentioned, Trump is talking about defunding the agency altogether. They don't need to expand exponentially by magnitudes of order the number of items that they screen in only to screen out. So I don't think it's necessary. But I do understand the way the law works, right? It says thou shalt promulgate this rule, and that language is there. So, there could be some movement with Congress to change that in upcoming legislation. But, assuming that doesn't happen, I think we should have a challenge so that we can negotiate further the information and the concerns and the issues that were raised in the comment process. Normally, that should be done in comment, and then you wouldn't have to litigate. But here, there was just no time. So the agency, I would think, has an interest in meeting with not just the owners, operators of the world, but also the environmental groups, also the unions who commented, everyone, to get them in a room to talk about, okay, how does this scope out so that we can protect the integrity of the CSB and its mission, and also render this rule workable for owners, operators. That would be the goal. Again, I'm maybe reading tea leaves a little bit here, but based on the positions that were taken by the CSB in the litigation in 2018, I would expect that the CSB would be open to further dialogue on this rule, but they just didn't have time to deal with it under the court deadline that was established. So I encourage you to think about joining with other parties, working with us to support a petition for review. That would need to be filed. We have to confirm all this, but I believe it would need to be filed by about the third week in April. The Clean Air Act provides 60 days from the date of promulgation, publication in the Federal Register, which was just this past Friday. The petition for review is a very simple, it's not costly to prepare. It's a simple filing that just sort of identifies the parties and gives broad scope sort of reasons for the challenge. The real work then would come in the next stage, and that would be negotiating with the agency and with other parties on, you know, what this rule really ought to look like. All right, well, with that, I think, and I guess the final point I would make is I do think, from a legal perspective, I think there are legitimate bases, legal challenges that can be brought to this rule, even though the goal would not be a 2 or 3 year long litigation where there's briefing in court and, you know, oral argument and all that. I think the goal would be a shortened process where we negotiate with CSB and hopefully achieve the objective, and then the rule could, the litigation could be settled. All right, with that, let me thank you all for your time. On behalf of Eric, Beeta, and I, we're pleased to talk to you today, and we are open and available basically 24/7 to talk to you further if you have further questions about the rule, about compliance, and or about a legal challenge. Thanks, everyone, and have a very, very good afternoon. Stay safe.
Actually, if anybody is interested, we're just looking through the questions that have come in through the chat
Yes.
box right now. There's a question about the knowledge function.
Okay, so, question here. What if you get knowledge, i.e. of the triggering event, i.e. the hospitalization, for instance, after the 8-hour reporting window? What does that mean? Well, to the questioner, I wish that I could give you an answer, but unlike the OSHA rule, where it's clear what that means, it means that when you get that knowledge, you have 8 hours to report. Because the CSB rule is not written that way, theoretically, you are already in violation when you get that knowledge. Now, that's an absurd interpretation, I get you, but I also think as a lawyer, you know, you've got to read the rule the way it's written, and I think this is an area where, to the commenter and the questioner, this is an area that is amply suited for discussion with CSB. Again, unfortunately, now we're talking about it in the context of a litigation because they had to rush through the rulemaking process.
Right.
So,
and in the final rule, it kept the within 8 hours. You have to report within 8 hours of the accidental release. So again, that knowledge element is not there.
yes. Okay. So another question, does the rule apply even if a facility is not subject to Clean Air Act permitting or state or federal permitting, such as de minimis or exempt sources? The answer is yes. There is no exemption that parallels the Clean Air Act exemptions for permitting that you're asking about. Question, so the amount of the release is not the determinant?
That's right.
Oh, the amount of the release, yeah, no, absolutely.
You have to report it.
Yeah, the amount of the release has nothing to do with whether you have to report or not. It could be a, you know, I'm exaggerating to make an effect, but it could be a thimbleful release, a very, very, very minor quantity release that does not trigger, for instance, NRC reporting obligations, but because it's under the threshold, but yet if it causes a triggering event, property damage, serious injury, fatality, you have to report. Now, query how many of those are where you spill a thimbleful of something and it causes that, I don't know, but certainly legally the answer is yes.
you know, a beaker breaks in your lab and someone is hospitalized, inpatient hospitalization because of inhalation or because of a burn.
Very good point. Very good point.
I mean, absolutely. That's part of the idea where I feel like the definition of serious injury is broader than it should be for purposes of reporting to the CSB, because the CSB is not going to respond to and investigate an incident like that. It is reportable to OSHA. It's recordable on your OSHA log. There is an agency out there who deals with relatively minor incidents like that, and it's just going to be a wasted call to the CSB, wasted resources by the CSB screening it.
Yeah, and I'm just going to affirm what Eric said. We're not even saying that that beaker spill that results in a burn of a hand is a minor incident in the context of OSHA. OSHA has authority for those things, and we take that seriously. But for CSB to get that, that's what we're talking about being, you know, unnecessary. So.
Yeah, good question here about the trigger for the inpatient hospitalization for care, I think was language that we used on the slide. Is that the same as for treatment under OSHA reporting? And the answer is yes. They were trying to mimic the requirements under the OSHA reporting standard. There are some differences, but the concept there is that you're admitted to the inpatient service of a hospital for medical treatment. And it is the same concept as the OSHA reporting rule in that regard.
Another comment, is the CSB going to issue a response to comments? No. I mean, you know, no, not some formal issuance of a response to comments. They have issued their final rule. Now, in the context of the,
right.
And the preamble, right. The preamble essentially is their response to comments. In the context of this upcoming guidance that they indicate they're going to issue, they may be dealing, I suspect they will deal with some of the comments that were raised, but no formal response to comment beyond what we've already seen, which is the preamble to the final rule, sorry. And I see someone said they didn't get the slides, so we'll make sure to resend those slides. Sorry about that. We sent them out, I think we sent them about an hour before the presentation, but we'll get them out again. Why not the administrative review first rather than through courts? I'm not sure I'm getting the full impact of the question, but the administrative process has ended now. There is no available process that we have, a formal process anyway, to address this, except if we file a petition for review that opens up a formal opportunity to dialogue with the agency. Now, I mean, you know, any citizen, I suppose, can call up CSB and, you know, and send a letter. It doesn't mean that can't be done, but there's no, you know, formal path to ensure that there's going to be engagement with the agency other than through filing a litigation at this stage of the process. And
by statute, if the regulation is not challenged within 60 days, there will be no opportunity to challenge it, right? Is that the Administrative Procedure Act or the Clean Air Act amendments? What is the? Yeah, no, the Clean Air Act itself provides the time period for someone to challenge a rule that is promulgated pursuant to certain sections of the Clean Air Act, including the statutory section that was the organic statute requiring the promulgation of this reporting rule. Hey, really great questions in this webinar. I'm excited this might be the one that people's heads were not down on the desk sleeping. I'm really impressed with the questions here. There's another good one about the Paperwork Reduction Act
Okay,
issues.
Yeah, so discuss the fact that the CSB has not yet obtained PRA clearance from OMB. Okay, so...
Does this relate to the idea that CSB has not designated this as a significant rule or whatever that is?
Yeah, I mean, there are definitely Paperwork Reduction Act requirements that are associated with, quote, significant rules. Those significant rules are defined by meeting a certain dollar figure associated with compliance Here, the CSB has determined that this is not a, quote, significant rule because it will not cost a lot of money to comply with, and therefore certain of the paperwork obligations are relaxed. In fact, do not apply. So I don't know if that answers the question or not. I will tell you, just as a sort of related point, one of the comments that we made on the proposed rule was that the CSB had underestimated the cost of compliance. And I want to be careful here not to sound like a crazy person that says, like, it's going to cost us, $3 trillion to comply. We get that it's a fairly, concise reporting form, and there is now this interactive thing. So CSB analyzed the amount of time it would take to, one, learn the rule. CSB said in the first rule it would take approximately 45 minutes, I believe, to kind of read the rule and learn the rule. That's probably a little bit low. And then it estimated, and if I'm getting this right, I apologize if I can't quite remember, I think it estimated like some very short amount of time, like 7 minutes, to fill out the form and send it in. Here's the deal, everyone. We're not saying that time is what's so underestimated or that cost is what's so underestimated. Once you get to the point of filling out the form, agreed. Most of the questions are fairly straightforward and you've got answers. And they've got that if known language built into certain of the questions. The cost comes in evaluating whether you meet a trigger. Again, in particular, the property $1 million trigger, that's going to be very costly to figure out whether, how much the cost is associated with over the fence line damage, if any, and loss of use. Those are things that either, insurers, risk assessors, and or your accountants put together. There's time and money and effort associated with that, and some of that maybe already is done for other reasons, internal to the company, and those costs wouldn't count, but the rest of them would, and those costs could be significant.
Yeah, there's another good question that under the current rules, prior to this rulemaking, how does CSB obtain notice of significant releases? And there are a lot of different ways. I think Kate talked about some of them, but first of all, the NRC reports, and Beeta can actually fill this in, make it accurate for what I'm about to say, but my understanding is that there is already, if not an informal memo of understanding between NRC and CSB, where NRC reports everything that is reported to the NRC is shared with the CSB within some very short period of time, even before this rule exists, right?
Right, that's right. Anything that the NRC gets that's within the CSB's jurisdiction, the CSB and NRC do have an agreement together. So anything that it gets, NRC gets, that's within the CSB's jurisdiction is sent immediately to CSB.
And in fact, guys, there's a statutory requirement under the Clean Air Act that occurs. So this isn't just in an informal or formal MOU between the agencies. This is statutorily required.
Right.
And it's happening by the end of whatever day the NRC got the report, within a short period of time.
Yeah.
So all of the NRC reports, CSB is automatically getting. There is, what Kate talked about, just the internet, and if you look at CSB's website on the front page, you can see that I don't know if they have some sort of software that does this, or if they've got a person who does this, or they set Google alerts or what, but they are clearly combing the internet for anything that sounds like a chemical-related incident that is within their jurisdiction, and they link to the articles that are out there just in local and regional and national media about incidents like that. So, and those are frankly the ones that they're reporting, that they're responding to and investigating.
Right.
So between the NRC reports and the work that they're doing, sort of, surfing the internet, or I assume they have something that at least triggers a notice to them about these stories, they are getting information about every incident that they would in a million years respond to, and now they're going to get a bunch of, things that they won't respond to, and it's going to waste a lot of time, plus duplication of reports of things that they've already heard about, either from the internet or from the NRC.
And, this is not just Eric, Beeta, and I and those of you who are part of our industry coalition who share this view. The I don't know the title of the fellow at the CSB, who filed an affidavit in the litigation, but,
The Director of Investigations.
yes, thank you,
Mr.
Beeta.
Kleist, yep.
Yes, Mr. Price, the Director of Investigations at the CSB, said the same thing in his affidavit, that the Internet is available now, and it is a source of information to the CSB that provides all of the information that it would need to identify an initial event. Now, does it provide all the information that the CSB needs about that event? If it's a catastrophic event and the CSB wants to investigate, no, it does not necessarily. And, newspapers get it wrong as much as, or often anyway, and some would say as much as they get it right. So we're not suggesting that all of the information can be gathered from the media report, but the event itself can be. CSB then has the ability, and in fact, the way it currently works is they then follow up with the original, or with the entity to, learn about the event, to gather the sufficient information to determine whether it reaches the level of being investigated.
Sometimes they know from the initial report, we're going to respond to this. Other times, they will send an initial information request to the employer to find out, is there something here that would be an interesting subject for us to investigate and write about, or are the consequences broader than maybe we can tell from an initial story? And that's available to them. They have subpoena authority, and they can do all that even without this rule. A question here that says, do you believe that a report to NRC and then giving the ID number to CSB must include all the information specified in the CSB reporting rule? The answer is no. The only thing you're required to give to the CSB if you've already reported to NRC is the NRC number, even if, for whatever reason, the information shared with NRC doesn't check every box on the CSB's reporting rule content. If you've reported to NRC, you have that NRC ID number. That's the only thing right now, as the rule is finalized, that you need to share.
And I think maybe the question's also asking the flip. Does the NRC report, do you believe a report to the NRC must include all the information? And no, the NRC, just like Eric said, the NRC report has to include what is required pursuant to CERCLA, not what is required to pursuant to CSB.
This question, can we post a link to the final rule? Yes, I would encourage everybody to check out our blog, the OSHA Defense Report blog. We've got a couple of articles, maybe even 3 articles up there about this rule, but the final rule link would only be in the final article that says, hey, there's a final rule. So check that out, but when we circulate information about this webinar, we'll be sure to include that as well.
I see. And I see sorry, thanks for clarification to the commenter here. First of all, question about universities, an exemption for
research universities.
Yeah, research universities. No, there's no such exemption. Research universities are covered just like petroleum refineries. And I see what you're saying now, a commenter, about it's not a significant rule but still requires OMB clearance. So, very interesting. OMB, the fact that OMB had not issued clearance on a rule that was finalized, I do not, I don't know what to say there. I've never
It might be the case they were just trying to get to the court mandated deadline.
Right.
Yeah. I mean, I'm sure that's why. Beeta's saying it's because they tried to get to the court mandated date, and so they moved forward to meet their district court obligation, notwithstanding the fact that the OMB had not cleared the rule.
And that's true as of today, right? There's still no OMB clearance?
Yeah.
Right.
This is the final rule that was published on Friday. Yeah.
I mean, I'll tell you one thing. So the OMB, of course, is the White House, right? A branch of the White House. So, from a political standpoint, if you're thinking about, how to deal with this, there's obviously an avenue that is a political one, to go directly to the White House. Legally, is that a basis to challenge the rule? Perhaps so. I'd have to look at the obligations to have clearance from the OMB. So it's a really good point, and we will for sure look at that you know, make sure we identify all legitimate bases to challenge the rule in a petition.
Yeah, so there, somebody asked about the PDF fillable form that CSB has indicated would be available when the rule was finalized and effective. We can't find it either.
Probably when it becomes effective in March.
Oh, right, because it's still,
March 23rd.
It's not effective for
30 days.
30 days from
Friday.
publication last Friday. So sometime in the next 30 days, that form should appear, and events become reportable starting that effective date in the future. And then if that form is not available, is there some other way for people to report?
If that form does not become available, then you can call it in.
Call it in or email.
Or email, that's right.
And those are both in the Federal Register, both of those.
Both the contact information.
Yep.
Yeah, another really good question here about, to clarify, the injury and illness definition, the serious injury definition in the CSB rule now matches OSHA's reporting requirements. It's nearly so. It matches OSHA's reporting requirements for fatalities and for inpatient hospitalizations, except for the time period. Everything is 8 hours under the CSB rule. Under OSHA's reporting rule, it's 24 hours for a hospitalization. There is no special call-out for amputations or loss of an eye in the CSB reporting rule. It's only fatalities and inpatient hospitalizations for medical care. One other thing that I don't see in the CSB rule that is different is for the OSHA reporting rule, there's different time triggers. First, there's the 24 hours from when you learn about the hospitalization, right? Kate talked about how that doesn't apply. The other big element here that I think is really important, for OSHA reporting of a hospitalization, you need to be admitted to the inpatient service of the hospital within 24 hours of the event. And you would be absolutely stunned at how often that little timing issue becomes relevant and makes hospitalizations not reportable. There is no such limitation that I can see in the CSB rule. So if someone is admitted to the inpatient service, 2 or 3 days after an incident, that would still be reportable to the CSB, although probably not reportable to OSHA. And I'd encourage you to call us for any of this. If you think you have a reportable CSB incident or a reportable OSHA incident on your hands, don't ever hesitate to call us. We're very happy to give you a little free advice on whether you've got a reportable on your hands. The CSB form is not yet available. So many questions. This is wonderful. So there's more talk about the OMB issue.
I was just looking at one. Did you state that the final rule was published in the Federal Register on 2/21 with an effective date of 3/23/20? Yes and yes. You can pull up last Friday, the 21st of February's Federal Register, and we can link that to you as well, I believe. When we send out our slides again, we'll send you a link to the Federal Register. Sure, absolutely.
All right, I think we got to the end of that list of questions. That's awesome. It does seem like this was an important bonus webinar session, and I'm glad we did this, and I'm glad you all could join us, and I hope that this doesn't exhaust you too much to prevent you from joining our partners tomorrow, who will be talking about OSHA settlement tips and strategies. So thanks everybody for joining us today, and if you have any additional questions about this rule, interest in joining a coalition to challenge the rule, please do reach out to us. We are trying to organize that group right now, and hopefully we do have enough interest to support doing that. And we will be in touch about this rule as it evolves, so definitely register, sign up for our blog, and check that out. All right, thanks everybody, and have a great rest of the day.
Thank you.